Soliman M. Santos versus Attorney Francisco R. Llamas, AC number 4749, January 20, 2000. Facts. This is a complaint for misrepresentation and non-payment of bar membership dues filed against respondent Attorney Francisco R. Llamas. In a letter complaint to this court, complainant Soliman M. Santos, Jr., himself a member of the bar, alleged that, "I wish to bring to your attention and appropriate sanction the matter of Attorney Francisco R. Llamas who, for a number of years now, has not indicated the proper PTR and IBP OR numbers and data, date, and place of issuance in his pleadings. If at all, he only indicates IBP Resol 259060, but he has been using this for at least 3 years already. This matter is being brought in the context of Rule 138, Section 1, which qualifies that only a duly admitted member of the bar, who is in good and regular standing, is entitled to practice law. There is also Rule 139, Section 10, which provides that default in the payment of annual dues for 6 months shall warrant suspension of membership in the integrated bar. And default in such payment for 1 year shall be a ground for the removal of the name of the delinquent member from the roll of attorneys. Please note that while Attorney Llamas indicates IBP Resol 259060 sometimes, he does not indicate any PTR for payment of professional tax. Finally, it is relevant to note the track record of Attorney Francisco R. Llamas, as shown by his dismissal as Pasay City Judge, his conviction for estafa, respondent alleged. Supreme Court dismissal decision was set aside and reversed, and respondent was even promoted from City Judge of Pasay City to Regional Trial Court Judge of Makati. Complainant need not even file this complaint if indeed the decision of dismissal as a judge was never set aside and reversed, and also had the decision of conviction for a light felony, then affirmed by the Court of Appeals. Undersigned himself would surrender his right or privilege to practice law. Undersigned since 1992 have publicly made it clear per his income tax return, up to the present, that he had only a limited practice of law. In fact, in his income tax return, his principal occupation is a farmer, of which he is. Moreover, and more than anything else, respondent being a senior citizen since 1992, is legally exempt under Section 4 of Republic Act 7432, which took effect in 1992. In the payment of taxes being thus exempt, he honestly believe in view of his detachment from a total practice of law, but only in a limited practice, the subsequent payment by him of dues with the integrated bar is covered by such exemption. In fact, he never exercised his rights as an IBP member to vote and be voted upon. IBP Board of Governors passed a resolution adopting and approving the report and recommendation of the investigating commissioner, which found respondent guilty and recommended his suspension from the practice of law for 3 months and until he pays his IBP dues. Respondent moved for a reconsideration of the decision, but this was denied by the IBP. Hence, pursuant to Rule 139b, Section 12b of the Rules of Court, this case is here for final action on the decision of the IBP ordering respondent's suspension for 3 months. Issues. On the first issue, complainant has shown respondent's non-indication of the proper IBP OR and PTR numbers in his pleadings, more particularly his use of IBP Resol 259060 for at least 3 years. On the second issue, complainant claims that respondent has misled the court about his standing in the IBP by using the same IBP OR number in his pleadings of at least 6 years and therefore liable for his actions. Ruling. First, indeed, respondent admits that since 1992, he has engaged in law practice without having paid his IBP dues. He likewise admits that, as appearing in the pleadings submitted by complainant to this court, he indicated IBP Resol 259060 in the pleadings he filed in court, at least for the years 1995, 1996, and 1997, thus misrepresenting that such was his IBP chapter membership and receipt number for the years in which those pleadings were filed. He claims, however, that he is only engaged in a limited practice and that he believes in good faith that he is exempt from the payment of taxes as a senior citizen since 1992. Rule 139a provides. Section 9. Membership dues. Every member of the integrated bar shall pay such annual dues as the Board of Governors shall determine with the approval of the Supreme Court. A fixed sum equivalent to 10% of the collections from each chapter shall be set aside as a welfare fund for disabled members of the chapter and the compulsory heirs of deceased members thereof. Section 10. Effective non-payment of dues. Subject to the provisions of Section 12 of this rule, default in the payment of annual dues for 6 months shall warrant suspension of membership in the integrated bar, and default in such payment for 1 year shall be a ground for the removal of the name of the delinquent member from the roll of attorneys. In accordance with these provisions, respondent can engage in the practice of law only by paying his dues, and it does not matter that his practice is limited. While it is true that RA number 7432, Section 4 grants senior citizens exemption, the exemption does not include payment of membership or association dues. Second, by indicating IBP Resol 259060 in his pleadings and thereby misrepresenting to the public and the courts that he had paid his IBP dues to the Resol chapter, respondent is guilty of violating the Code of Professional Responsibility. Rule 1.01. A lawyer shall not engage in unlawful, dishonest, immoral, or deceitful conduct. Canon 7. A lawyer shall at all times uphold the integrity and dignity of the legal profession and support the activities of the integrated bar. Canon 10. A lawyer owes candor, fairness, and good faith to the court. Rule 10.01. A lawyer shall not do any falsehood, nor consent to the doing of any court, nor shall he mislead or allow the court to be misled by any artifice. Respondent's failure to pay his IBP dues and his misrepresentation in the pleadings he filed in court indeed merit the most severe penalty. However, in view of respondent's advanced age, his express willingness to pay his dues and plea for a more temperate application of the law, we believe the penalty of 1 year suspension from the practice of law or until he has paid his IBP dues, whichever is later, is appropriate. Attorney Francisco R. LLAMAS is suspended from the practice of law for 1 year, or until he has paid his IBP dues, whichever is later.